Okay.
Yes, you guys start.
Start here, right?
Oh, start.
Okay. So, good evening, everyone. So, today we are going to deal about forensic medicine and toxicology. So, in forensic medicine, we are particularly the forensic medicine, 3 chapters, first 3 chapters. So, other thing will be dealt in the later sessions. Yes, so I am doing my PG in Government Homeopathic Medical College, Bangalore. So, going straight into the topic. So today we are going to deal about these 4 topics. First, forensic medicine, the introduction, and the terms and branches of forensic medicine we will deal. Then legal procedures, medical law and ethics, and identification. These 4 things we are going to deal today. So forensic medicine, what is forensic medicine or legal medicine? The other term for forensic medicine is legal medicine. So, forensic medicine deals with the application of medical and paramedical knowledge to aid in the administration of justice. So, it is used by legal authorities for the solution of legal problems. So, it is a application of medical and paramedical knowledge to aid administration to justice. Medical knowledge in the sense means the knowledge with practice of medicine, and paramedical knowledge, the supporting system like radiography and nursing, other supporting factor to medicine. So these medical and paramedical knowledge together deal together with gives an aid to administration of justice. That is what forensic medicine is. So it is used by legal authorities for the solution of legal problems. Okay. So examples of some of the examples are injury, suicide, accident. These type of conditions, application of medical and paramedical knowledge is done. Okay. So next is forensic medicine. The forensic medicine word is originated from Latin, and which means forum. So forum in Rome, forum was a meeting place where civil and legal matters used to be discussed. So in Rome, forum was meeting place where civil and legal matters used to be discussed. Like our court nowadays, our court, what it is, same thing happens in Rome, where civil and legal matters happens. That place is called forum. So with that word, forensic came. It is a Latin word. So synonym for forensic medicine is legal medicine. Okay. Next is history about forensic medicine. The first book on forensic medicine was published in 1602 by an Italian physician, Fortunato Fedele. And it is considered that the father of forensic legal medicine as well as father of forensic psychiatry was Paulus Secchias, and the founder of modern toxicology is Orfila. Okay, these are related to history of forensic medicine. Next is branches of forensic medicine. So in first we had learned about the definition, history, and then the branches of forensic medicine. Branches consist of 11 part I had included. One is forensic pathology, second is clinical forensic medicine, third is forensic toxicology, fourth is forensic thanatology, fifth is medical ethics, sixth is medical jurisprudence, and seventh is forensic odontology or forensic dentistry, 8 is forensic psychiatry, 9 is forensic anthropology, 10 is forensic entomology, 11 is forensic serology. So 11 part I had included. So we will deal in detail about these things. Okay. So first is forensic pathology. So the knowledge of medicine is used to find out the cause of death by performing autopsy or post-mortem examination. Here in forensic pathology, the after death, with autopsy or with post-mortem examination, to find out the cause of death. So here in traumatic death, sudden unexpected death, interpreting the mechanism of injuries, and giving medical legal opinion. For these condition, for these terms, uh, autopsy or postmortem examination is done. So this forensic pathology is done after death happens. Okay. Second is clinical forensic medicine. It is like investigation in living person and assessment of medical finding. This is done in living persons as an investigation part for assessment of medical findings. So in example, like in condition like medical legal examination of sexual offenses, determination of age for medical legal purposes, medical legal examination of injuries in physical assault, battered baby. Battered baby means abused baby. So medical legal examination of drunkenness, assessment of degree of permanent disability following a factory accident of a workman for compensation. So in all these conditions where investigation is needed for assessment of medical finding, this is called clinical forensic medicine, where these things comes. Clinical forensic medicine is the term used. Okay. Next is forensic toxicology. Toxicology, we all know about toxins, study of toxins. So here, analysis of biological samples for presence of toxins, including drugs. Okay. So deals with the source, character, property of poison, the symptom they produce, their fatal effect and fatal doses, and the remedial measure that should be taken to combat their action or effect. So this is all relating to toxins, dealing with the source of that toxins, that particular character when the toxin is consumed, properties of that poison, the symptom they produce. The property character in the sense means the appearance ways. The symptom they produce, if it is consumed, means what symptom they will produce, their fatal effect and fatal dose, the remedial measure that should be taken to combat their action or effect. Okay, that is forensic toxicology. Fourth is forensic thanatology. Forensic thanatology means scientific study of death and the losses brought about as a result. So all losses brought to a person or a brought to a person is comes under forensic thanatology. Investigate the mechanism and forensic aspect of death, such as bodily changes that accompanied death and the postmortem period changes. Okay, scientific study of death and the losses brought about as a result. That is forensic thanatology. Next is medical ethics. Medical ethics means deals with the moral principle, which should be guide members of the medical profession in their dealing with each other, their patients, and the state. So these are moral principle, medical ethics. So these medical ethics consist of 4 pillars. So first is beneficence, which is doing good. Second is non-maleficence, to do no harm. Third is autonomy, giving freedom for patients to choose freely. Fourth is justice, ensuring fairness. Okay, these are the 4 main pillars for medical ethics. Medical ethics deals with moral principle. Okay, and next is medical etiquette. Medical etiquette means deals with the conventional law of courtesy observed between members of medical profession. So it is the conventional law of courtesy, medical ethic. Next is medical jurisprudence, which is branch of science and medicine involving the study and application of scientific and medical knowledge to legal problem. So here, it is a science. Medical jurisprudence is a science and medicine involving the study and application of scientific and medical knowledge to legal problem. So these medical and scientific knowledge is put to legal, solving the legal problems. So physician-patient relationship, medical negligence, consent, right and duties of doctors, serious professional misconduct. In short, it deals with legal aspect of practice of medicine. So this all comes under medical jurisprudence. Next is forensic odontology or forensic dentistry. Deals with the proper handling examination, and evaluation of dental evidence for the interest of justice. So forensic odontology in the sense means study about teeth. So here deals with, forensic medicine deal with the proper handling, examination, and evaluation of dental evidences for the interest of justice. So forensic odontology are responsible for identifying human remains that cannot be identified using fingerprints or other means. So identifying body in mass disasters, example plane crashes, determine the sources of bite mark injury in case of assault or suspected abuse. Next is estimate the age of skeletal remain. So if very limited knowledge about a particular body is there, or about a case is there, means like a body is there means, here with odontological data we can find out the cause, about the age, everything we can understand. So it deals with proper handling, examination, evaluation of dental evidences for interest of justice. With dental evidence, we are finding out uh, uh, things for justice. Okay, so that is for forensic odontology. These are branches of forensic medicine. Okay, next is forensic psychiatry. Psychiatric assessment of person. Forensic psychiatry deals with psychiatric assessment of person, insanity in case of murder, competence as a witness, uh, testamentary capacity, mental ability to make a valid will. Testamentary means in executing a will. Okay, validity of consent. So psychiatrical assessment of person is dealt with forensic psychiatry. Okay, next is forensic anthropology. In forensic anthropology, it assists in the identification of deceased individual whose remains are decomposed, burnt, mutilated, or otherwise unrecognizable. So here, forensic anthropology is a special subfield of physical anthropology, the study of human remains, that involve applying skeletal analysis and technique in archaeology to solve criminal cases. So anthropology means study from like long back things. Here, human remains, like skeletal analysis, skeletal. If we got a skeletal stature means, we'll study with the skeletal stature. It is male or female. Any assault happened to that. Study with those remnants means that is relating to forensic anthropology. Okay. So next is forensic entomology. Entomology means study about the insect related things. Okay. So forensic entomology covers evidence gathered through insect study at the scene of murder, suicide, rape, physical abuse, and contraband trafficking. Okay. Here, through insect study, the evidence is gathered. So helpful in determining the postmortem, interval, and location of death in question. Okay. Next is forensic serology. Forensic serology means detection, classification, and study of various body fluid, blood, sweat, semen, fecal matters, and their relationship to crime scene. So in forensic serology, detection, classification, and study of various body fluid is done. Okay. So this is about branches of forensic medicine. Now I'm dealing about some terms. Indian Penal Code, which was established in IPC 1860. IPC is the principal criminal code of India. It deals with substantive criminal laws of India. It defines offenses and prescribe punishment. So Indian Penal Code, it deals with substantive criminal laws of India, defines offenses and prescribe punishment. It's a criminal code, like written criminal code of India. That is Indian Penal Code. Criminal Procedure Code, CRPC, which was established in 1973. It provides the mechanism for punishment of offenses against the substantive criminal law. It deals with police duty in arresting offenders, dealing with absconders in the production of documents. Okay. In criminal CRPC, it provides the mechanism for punishment of offenses against the substantive criminal law. Here, Indian Penal Code, the principal criminal code, it is deal with substantive criminal law of India. And criminal procedure code is mechanism of punishment of offenses against the substantive criminal law. Okay, that is the difference. And another thing is Indian Evidence Act, IEA, 1872 it was established, deal with law of evidence, different categories of evidence, the procedure of collection, preservation, use of different evidence. Okay. So these are three things, IPC, CRPC, and IEA. So next we are going into proper legal procedures. These are first chapter, legal procedure. In legal procedure, we want to know about criminal law, civil law. Criminal law, what criminal law is, deals with offense which are considered to be against the public interest. So if someone is doing a offense uh, which is against public interest is called criminal law. Example, theft, assault, murder, robbery. Okay. But in civil law, deals with dispute between two individuals or parties. The party bringing the action in civil case is called plaintiff. The accused is called defendant in both criminal and civil cases. The accused is called defendant. Okay. Example, landlord disputes, divorce proceedings. Okay, the main difference is in criminal law, it is against the public interest. Civil law means two disputes between two people. Example, divorce proceedings, landlord disputes. Okay, that is the two things. Next is inquest. Inquest is an inquiry or investigation into the cause of death. An investigation which is done for a cause of death, that is inquest. It is conducted in case of suicide, murder, killing by an animal or machinery, accident, death due to torture or ill treatment, occupational disease, suspect medical negligence. So in all these conditions like suicide, murder, killing by any means accident also, first a preliminary investigation or inquiry will be done. That term is called inquest. So two types of inquest are there. So first is police inquest. Second is magistrate inquest. Okay. In police inquest, the officer in charge of police station conduct the inquest. Okay. Inquest means inquiry. The police officer will go there, inquire what are all things happen. It is normal or abnormal thing happen. The police person will inquire about that. Okay. The officer in charge of police station conduct the inquest. Okay. The police officer making the inquest is known as investigating officer. Second is magistrate inquest. So magistrate inquest in the sense means their magistrate or the person who had the power relating to in relation to magistrate level can do the inquest. This is done in particular situations like death under police custody, okay, death during police firing, death in prison, and death in psychiatric hospital, dowry death, then exhumations. So these are all conditions where magistrate inquest is needed. Where police inquest won't be done, here in these condition magistrate inquest is done. Okay. Other than these two, here I had mentioned police inquest and magistrate inquest. Other than these, coroner's inquest is also there. Uh, coroner's inquest is done in United Kingdom and USA, but not in India. So here, lawyer or medical man with legal qualification of rank of first class magistrate is appointed by the government. So here, lawyer or medical man with legal qualification, rank first class magistrate appointed by government is appointed as coroner's inquest. This is not followed in India. This is inquest done in UK and USA. Okay. In India, it is the inquest followed is police inquest and magistrate inquest. Okay. So next is courts of law. So in section 6 to 25 of CRPC deal with constitution of criminal courts and office. So two types are there. First is civil code, second is criminal code, and one more is there, both civil and criminal code. So civil code, criminal code, civil and criminal code. So about criminal code, first three criminal codes are there. First is Supreme Court, the highest judicial tribune in India. It is located in New Delhi. So it is the highest judicial tribunal. So that is Supreme Court. Second is High Court, is usually located in capital of every state. Third is Sessions Court, is established by state government and is located at the district headquarters. So three courts are there. Supreme Court, which is the highest tribunal. Second is the High Court, which is located in every state. And third is the Sessions Court, located in district headquarters. It is established by government, state government, and is located in every district headquarters. Okay. So next is power of magistrate. A magistrate power. So chief judicial magistrate. A chief judicial magistrate can give 7 years imprisonment and he can fine unlimited fine. Okay. First class judicial magistrate, he can fine up he can give imprisonment up to 3 years and fine 5,000 rupee fine. And second class judicial magistrate, 1 year imprisonment and 1,000 rupee fine. So these three magistrate, we need to understand like how much fine and imprisonment they can give. Like chief judicial magistrate, 7 years imprisonment and unlimited fine. First class judicial magistrate, 3 years imprisonment and 5,000 fine. Second class judicial magistrate, 1 year, up to 1 year imprisonment and 1,000 rupees fine. Okay, the courts of law, Supreme Court, High Court, Session Courts. And power of magistrate means chief judicial magistrate is there, first class judicial magistrate is there, second class judicial magistrate is there. So these things we need to give importance, like in APGT examinations, these sort of things are we need to give importance to. Okay, and the terms also we need to give importance. So just for understanding those terms and all. So capital punishment. Capital punishment means death sentence. So method of capital punishment, this is given in textbook. So capital punishment is death sentence. So method of capital punishment is hanging first, electrocution, lethal injection, gas chamber, garroting. So hanging is commonly done. Okay. Next is cognizable offense. Cognizable offense means what? Cognizable offense means offense in which police officer can arrest a person without warrant from magistrate. Usually what happens is a police officer, if he want to arrest a person, means he need a valid warrant from magistrate. So here some cognizable offenses are there where police officer don't need any permission from magistrate to arrest a person. So examples are murder, rape, dowry death, ragging, death due to rash or violent act. So in some offenses, the individual is sent by police to the doctor for medical examination also. So cognizable offense is offense in which the police officer can arrest a person without warrant from the magistrate. Okay. Next is subpoena or summons. Summons means it's a written document issued by court and served in the witness under a penalty in all cases by police officer to attend the court for giving evidence on a particular day. So summons means it's a written document issued by court for the party to attend the court for giving evidence in a particular day. So if he is not coming, means it is penalty can be done, or case can he can be put into jail with cases. He can charge cases for not appearing in the court. So it is a document issued by the the court for giving evidence on a particular day to that party. Okay. So conduct money. Conduct money means fee offered or paid to a witness in civil case at the time of serving the summons to meet the expenses for attending the court. So conduct money is given in civil case. Okay, civil case means we had dealt earlier, deals with dispute between two individuals or parties. Criminal means it's an against a public interest. If some offense is happening, means criminal. So in civil case conduct, civil cases conduct money is given. Like for summons, if person is coming for giving evidence, means that money is given. That is conduct money. Okay, fee offered to or paid to a witness in civil case at the time of serving the summons to meet the uh, expenses for attending the court. That is conduct money. So it is given in civil cases. Next is witness. Witness, a person who gives evidence regarding the fact. The person who gives evidence, that is witness. So witness are classified into three types: common witness, expert witness, and hostile witness. Okay, common witness means a person who gives evidence about the fact observed or perceived by him. Common means a common person who had seen a crime, means he will give his idea about the thing happened, what he observed, what he had seen, that he will express. That is common witness, the person who give evidence about fact observed or perceived by him. An expert witness means is a person who has been skilled in technical or scientific subject and capable of drawing opinion and conclusion from the fact observed by him. So expert witness in the sense means he is technically skillful. Doctors are somewhat technically skillful. So doctors are can be considered as an expert witness. So is a person who has been skilled in technical or scientific subject and capable of drawing opinion and conclusion from the fact observed by him. That is expert witness. Hostile witness means is one who is supposed to have some interest or motive for concealing part of truth. So some person will hide uh, the truth for some needs. Those are hostile witness. So three types are there: common witness, expert witness, and hostile witness. These terms we need to understand. We need to know these terms. So perjury. Perjury means giving willful, false, fabricated evidence by a witness under oath or failure to state what he knows to believe to be truth. So giving willful, false, fabricated evidence is called perjury. Perjury and hostile witness should be differentiated. Hostile witness is one who is supposed to have some interest or motive for concealing part of truth. And perjury means giving false, fabricated evidence. Okay. So next is medical laws and ethics. So in medical laws and ethics, first we need to know about Indian Medical Council. Indian Medical Council, the function of Indian Medical Council, the first and foremost function is medical register, making or maintaining a medical register. So here medical register, the council maintain a register of medical practitioner known as the Indian Medical Register. So it contains the name of all the person who are enrolled on any state medical register. So all the registered medical practitioners will be included in this medical register. So if the name of the person enrolled on the state medical register is removed from the register, the medical council also remove from the register. So here the function is maintaining a medical register. First is Indian Medical Council, the function. So all the medical practitioners, registered medical practitioners will be enrolled in this medical register. Okay. Second is medical education. Medical education means the council had the authority to prescribe standard of postgraduate medical education for guidance of university. So they can change curriculum. Like if any particular curriculum is missing or need to be added for particular medical education, means they had the authority to add those things. That is relating to medical education. Third is recognition of foreign medical qualification. So here, if an Indian national obtains a foreign qualification, which is not included in part of the third schedule, second of the third schedule, he can apply to central government. So relating to all things relating to recognition of foreign medical qualification, the third thing is. Fourth is appeal against disciplinary action. So if the name of any person is removed from the state medical register, he may appeal to central government after exhausting all the remedies under State Medical Council Act. So appeal against disciplinary action. So if any action is taken, means they can give appeal in Indian Medical Council. Then warning notice. Warning notice, a registered medical practitioner is required to observe certain prescribed rules of conduct contained in Code of Medical Ethics, okay, published by Medical Council. The council give examples of offense which constitute serious professional misconduct. So warning notice also these in Indian Medical Association can produce. A warning notice in the sense means a registered medical officer practitioner are required to follow certain prescribed rules of conduct. If they are not maintaining those means, they can take disciplinary actions. Okay. So serious professional misconduct. Next is, it is any conduct of doctor which might reasonably be regarded as disgraceful or dishonorable. Any conduct, any way of behavior from a doctor which may be regarded as disgraceful or dishonorable, that is serious professional misconduct. In that cases, warning notice, like Indian Medical Council can give warning notice to that doctor. The warning notice, a registered medical practitioner is required to observe certain prescribed rules of of rules of conduct contained in Code of Medical Ethics published by Medical Council. The council give example of offences which constitute serious professional misconduct. Okay. If anyone is found guilty of any of the following offense mentioned in warning notice issued by Medical Council of India, his name can be erased from medical register. So from medical register, the name can be erased if anyone is doing this misconduct means. The examples of some of the misconducts are adultery, voluntary sexual intercourse between a married person and a person married or not other than his or her spouse. That is one thing. Second is issuing false, misleading or improper certificate in connection with sick benefit, insurance, passport, attendance in court, etc. So issuing a false evidence, false certificate for anything relating to insurance, sick, medical report, passport. So attendance in court means. Third is withholding from health authorities information of notifiable diseases. So notifiable diseases like that we will deal later also. In case of a person is having an infectious disease and he is working as a cook in some public hotel or public place, mean that should be informed. Another thing is syphilis person who is having bath on public swimming pool or anywhere, means it should be informed to authorities because those are notifiable diseases. These are notifiable diseases. So withholding the health authorities this information is also a misconduct. Fourth is performing or enabling an unqualified person to perform an abortion or an illegal operation for which there is no indication. So performing or enabling an unqualified person to perform an abortion or any illegal operation for which there is no indication. Okay. Fifth is contravening position. Provision of the Drugs and Cosmetic Act and Regulation, prescribing steroid, psychotropic drug where there is no absolute medical indication. So without indication, if prescribing steroids or psychotropic drugs, means that is also a professional misconduct. Sixth is not displaying the registration number given to him by state medical council in his clinic, prescription and certificate. So here, not displaying the registration number. So as part as the clinical act also, like for a hospital act also, the registration number should be mentioned in the prescription slip in the hospital board and all everywhere. So it should be maintained. Seventh is dichotomy. Dichotomy means, it's a word meaning means fee splitting, receiving or giving commission or benefit to a professional colleague or manufacturer or trader in drugs or application or chemist or dentist. So dichotomy means fee splitting, receiving or giving commission. Dichotomy is giving commission. Okay. Then 8 is using of toads or agent for procuring patient. For getting more patient, some may appoint some agents or toads. So that is also comes under professional misconduct. Then disclosing the secret of patient that have been learned during his professional experience, except in court of law and notified disease or privileged communication. So in the condition where we can disclose the secret of patients are when courts demands that time. Then when a notifiable, if it is a notifiable disease, means we need to disclose. Then privileged communication, certain diseases I told, like syphilis patients taking bath, it should be disclosed, right? So apart from these particular things, other all things relating to patient, it should be kept as secret. Professional secrecy should be maintained for other things. So if it is not maintained, means it is considered as a misconduct. So 10th is covering. Covering means assisting someone who has no medical qualification to attend, treat or perform an operation on some person in case requiring professional discretional skill. So covering means assisting someone who has no medical qualification. Non-medical qualified person can, if someone is doing some skillful medical procedure, means that is covering. Okay. 11th is advertising. A physician should not publish on his own in the lay press report of cases treated or operated by him. So advertisement publicly should not be encouraged. So 12th is sex determination test shall not be undertaken with the intent to terminate the life of a female. So here sex determination test shall not be undertaken with the intent to terminate the life of a female. 13th is a physician shall not publish photograph or case report of his patient without their permission. So if a physician is publishing a report or journal relating to some case or case series thing, means where the photo should be included, that time the permission, prior permission from the patient should be obtained. Otherwise, it is also a professional misconduct. So next is professional secrecy. Professional secrecy means the implied term of a contract between doctor and his patient. So the doctor is obliged to keep secret all that he comes to know, concealing the patient in course of his professional work. So what we meant was like relating to, if a particular person who is suffering from some disease or disease also, means, and that particular patient is disclosing uh, so many personal aspect of that thing to doctor, means that should be kept as secret. And in terms of privileged communication, when court demands, or in terms of any notifiable disease only, a doctor can reveal all these things. Otherwise, all the things that is said to be said by the patient should be kept confidential. Okay. Next is privileged communication. I mentioned it is the statement made bona fide upon any subject matter by a doctor to concerned authority due to his duty to protect the interest of community. So it is the statement made bona fide upon any subject matter by a doctor to concerned authority due to his duty to protect interest of community. If a patient suffering from infectious disease is employed as a cook, example. So here we need to, we have the privilege to communicate to the authorities. That is privileged communication. So here we need to disclose the things. Next is professional negligence. Professional negligence means professional negligence is defined as absence of reasonable care and skill or willful negligence of a medical practitioner in treatment of a patient which cause bodily injury or death of the patient. So professional negligence means without absence of proper care or skill or willful negligence by part of a doctor which cause bodily injury or death of a patient. That comes under professional negligence. So civil negligence, when a patient or in case of death, any relatives bring a suit in civil court. Civil negligence in these conditions, two aspects are there. First is when a patient or in case of death of a patient, relatives bring a suit in civil court for getting compensation from doctor, or when a doctor bring civil suit for getting his fees from patient or relatives when refuses to pay. So either a doctor can go or the patient or relatives can go. For this is civil negligence in terms of professional negligence, and if a doctor is not paid well. So the term res ipsa liquitor, the term the patient need not prove negligence in case where the rule of res ipsa liquitor applies, which means the thing or fact speak for itself. Here the patient need not prove everything, but the things and fact speak for itself. That term is this, res ipsa liquitor. Next is novus actus interveniens. A person is responsible not only for his action but also for the logical consequence of those actions. That is the meaning of novus actus interveniens. An unrelated action intervening. Next is a civil wrong is, the term for a civil wrong is tort. Oh, next is therapeutic misadventure. Therapeutic misadventure means a misadventure is mischance or accident or disaster. It can be an accident, disaster, mischance. Okay, three types are there where therapeutic misadventure can occur. Like if therapeutic means treatment side, any sort of accident or disaster is happening. That is therapeutic misadventure. In three ways it can happen in therapeutic aspect: when the treatment is given or not properly given, like not in the even if properly given also, that can therapeutic misadventure can accident can occur. In diagnostic way, when diagnosis only is the objective at that time, diagnosis is not properly done means it's a therapeutic misadventure. Experimental, when the patient has agreed to serve as a subject in an experiment. So in three ways therapeutic misadventure can occur. Next is vicarious liability. Vicarious liability means an employer is responsible not only for his own negligence but also for the negligence of employees. This term should be learned. Okay, employer is responsible not only for his own negligence but also for the negligence of employees. Okay, that is vicarious liability. Product liability means product liability refers to physical agents which cause the injury or death of patient during treatment by doctor. So product liability means product liability refers to physical agents which cause the injury or death. Vicarious liability means employer is responsible not only for his own negligence but also for negligence of employees. Product liability means product liability, physical agents which cause the injury or death of the patient during treatment by doctor. Physical agents. The injury or death of patient may result from unexpected byproduct of faulty, defective, or negligently designed medical or surgical instrument or inadequate operating instructions. So, product causing injury, that is comes under product liability. So next is dying declaration and dying disposition. So dying declaration, these terms should two terms is important. Dying declaration means he's a written or oral statement of a person who is dying as a result of some unlawful act relating to material fact of cause of his death. So dying declaration is a written or oral statement of a person who is dying as a result of some unlawful act relating to material fact of cause of death. Dying disposition means is a statement of person on oath recorded by magistrate in presence of the accused or his lawyer. So the statement of person on oath recorded by magistrate, that is dying disposition. Declaration is a written or oral statement of person who is dying as a result of some unlawful act. So this dying disposition is not allowed in India. Next is malingering. Malingering or shaming means conscious planned feignings or pretending a disease for sake of gain. So for sake of gain, pretending of having a disease, that is malingering. Example, diseases may be feigned for several reasons by policemen to avoid duty. That is malingering. Next is therapeutic misadventure, which means that due to some unintentional act by doctor or agent of doctor or hospital, which I mentioned earlier also, therapeutic misadventure, that due to unintentional act by doctor. Vicarious liability means the employer is responsible not only for his own negligence, but also for negligence of his employee. I mentioned that also. Next is euthanasia. Euthanasia is also termed as mercy killing, which is painless death of person suffering from hopeless, incurable, and painless disease. Euthanasia is not legally sanctioned in India. Okay. So it is painless death of person suffering from hopeless injury, incurable disease. So next is I am mentioning some of IPC and CRPC codes, which is important, which should be studied in APGT exam also. It is necessary, I feel. So first is section 37 to section 312 deals with medical negligence. Okay. So in section 44, IPC means injury. It is dealing with injury. And section 92, implied consent. Implied consent means consent which is not expressly granted by a person, but rather implicitly granted by person's action. Like traffic accident is an example. That is implied consent. So next is 191, perjury. Willfully telling an untruth. That is perjury. That is comes under section 191. Section 193 means witness can be prosecuted and punished for perjury. So punishment for perjury is mentioned in section 193. Section 197, issuing false certificate is punishable. Okay, section 197. Next is section 300, culpable homicide is a murder. Section 304, punishment for culpable homicide. So in section 300, culpable homicide is murder. Section 304, punishment for culpable homicide. And section 304A, B is there. Section 304A is causing death by criminal negligence. A is causing death by criminal negligence. Section 304B is dowry death. This is important. Many APGT exams, this section is asked dowry death related, which is mentioned in 304B. So section 320 means grievous injury. And section 351 means assault, make a physical attack on. Section 375 defines a definition for rape. Section 376 punishment for rape. So next is CRPC 174, which deals with investigation into case of death. So we had dealt earlier, like police inquest is there, magistrate inquest is there, and coroner's inquest also we dealt, which is not followed in India, which is followed in UK and USA. Coroner's inquest was followed in Bombay till 1999. Okay, now it is not following. So magistrate inquest done by executive magistrate, collector, deputy collector, tahsildar. In case of death in police custody, that due to police firing, death in prison, dowry death, and exhumation. Okay. Next topic is identification. So in identification, the first thing is corpus delicti. Corpus delicti means the elements of any criminal offense. Okay. So the corpus delicti of murder is the fact that a person died from unlawful violence. The element of any criminal offense is called corpus delicti. So the corpus delicti of murder is fact that person died from unlawful violence. It includes the body of the victim and other facts which are conclusive of death by foul play. It includes the body of victim and other factors which are conclusive of death by foul play. Okay, that is corpus delicti. Next thing we need to understand is race. Race in that with the head type of head, it is divided into three. We can classify race into three types: dolichocephalic, long headed, mesocephalic, and brachycephalic. Three types are there. Dolichocephalic means ranges from 70 to 85. That head index, it is 70 to 85. The race which is coming under dolichocephalic is Aryans, Aborigines, and Negroes. So Negroes, Aryans are coming under dolichocephalic, and metacephalic, their range is 75 to 80. The Europeans and Chinese are coming under that group. Brachycephalic means 80 to 85 percentage. The race coming is Mongolians. Then Gestaff method. Gestaff method means postmortem procedure to determine the age of an adult over 21 years, between 25 to 60 years. It depends on physiological age changes in each of the dental tissue. Gestaff method is age determination with dental tissues. So here these things are happening, which can be remembered as script. So first, what changes will happen in teeth are secondary dentin is occurring. After that, cement apposition will happen. After that, root resorption will happen. Third is root attrition will happen. And not third, fourth is root attrition. And paradontosis will happen next. Translucency will happen. So most reliable criteria will be translucency. After 60, from 55, 60 years, translucency will be happening. So age can be determined with translucency. So solely it is called most reliable thing. So Gestaff method is procedure for physiological changes that is happening in dental tissue. Okay. Then next we need to know is rule of Hess, which was formulated in 1895. This is a rough method of calculating the age of fetus. Rule of Hess is used for calculating the age of fetus. The length of fetus is measured from crown to heel in centimeter. So length of the fetus is measured from crown to heel in centimeter, during the first 5 months of pregnancy, the square root of length give the approximate age of fetus in month. So during the first 5 months, it will give the age, appropriate age. Like here I had mentioned, like if the child is having 16 centimeter, means the square root of 16 will be 4 months old. Likewise, age of the child is calculated. So rule of Hess is used for calculating age of fetus with the crown to heel length, Next is Galton system, dactylography. The word name we need to understand, like Gestaff method is physiological changes happening in dental tissue, and dactylography, what happens is, or Galton method, this is fingerprint or impression of fingerprint identification of person. That is Galton method. So fingerprint or impression of patterns found by papillary or epidermal ridge of the fingertips. The ridge patterns first appear between 12th to 16th week of intrauterine life, and the formation is completed by 24 weeks. So the ridge pattern of these fingerprints appear between 12 to 16 weeks of intrauterine life, and it will complete on 24th week. So here 4 types of fingerprints are there. And another thing is, this Galton method is the most reliable method of identification of person. Galton is there, Gestaff is there. Gestaff means changes in dental tissue. Galton means fingerprint analysis. Okay, so here 4 types of fingerprints are there. One is loops. Loops means loops are 67% of fingerprints. Whorls are there, 25%. Arches are 6 to 7%, and composite is 1 to 2%. Okay, so 4 types are there. The commonest type of fingerprint is loops, which is 67%, and the most least commonest thing is composite, 1 to 2%. That also you need to understand. And the thing you need to remember is, most reliable method of identification of person is Galton method or dactylography, and which Galton means fingerprint study, and Gestaff means physiological changes happening in dental tissue, which determines the age. Okay. Another one term is chiloscopy. Chiloscopy means study of lip print. The term name is study of lip print. Podogram is there. Podogram, the term means footprint. Okay. Another term is poroscopy. Poroscopy is the further study of fingerprint described by Lockhart. Doctor had mentioned an advanced study on fingerprint, which is called poroscopy. The ridge on fingers and hand are studded with microscopic spores formed by mouth of ducts of subepidermal sweat glands. So the ridge of the finger ridges are having so many subepidermal sweat gland pores. So each millimeter of ridge contain 9.9 to 18 pores. So these pores are permanent and unchanged during life and vary in size. So this study of this fingerprint pore is called poroscopy, which was described by Lockhart. The word name you should understand. Next, podogram, I mentioned footprint. Chiloscopy is study of lip print. Okay. Then skull photo superimposition. This technique was first applied by Gleister and Brash in 1935 in Rouston case. In one case, these 2 persons, Gleister and Brash, had applied this technique in 1935, skull photo superimposition. So in this, superimposition is technique applied to determine whether the skull is that of person in the photograph. A photograph is kept, and the skull obtained will be kept together and identified as, like, the hair they will keep artificial same relating to that photo. Hair will be made, and that is also tried with that skeleton is having. And likewise, the superimposition is made and identified the skull is similar to the skull of the photograph. That is skull photo superimposition. Okay. Next is tattoo mark. Tattoo mark designs made in the skin by multiple small puncture wound with needles. These tattoo marks are also an identification feature for an individual. Some person will be nowadays tattoo marks are so common, and with tattoo marks a person can be easily identified. The dye commonly used are Indian ink, carbon gives black, cinnabar or vermilion give mercuric sulfide, cinnabar or vermilion give mercuric sulfide, chromic acid will give green. So tattoo marks are important for identification. Trichology is the study of hair. So here human hair and animal hair also should be studied. Different should be known. So study of hair is called trichology. So medullary index of hair is used to determine species, animal or human species. Medullary index is used for that. Human hair is fine, thick, cuticular scales are short, broad, not continuous. Cortex is thick, 4 to 10 times as broader as medulla. Means medullary, 4 to 10 times as broader as medulla. Okay. So animal hair is coarse, thick, cuticular scales very large, step-like projection is there. Cortex thin, hair grows at 3 mm a week. So here trichology is study of hair, and medullary index of hair is used to determine species, animal or humans. So this is about today's topic. I think I had dealt 3 topics relating to forensic medicine.